Hello everyone, my name is Romit Shrestha and I'll be going through breach of contract and discharge of contract. Firstly, let's look at discharge of contract because they are both essential elements of a contract. And for this, I have chosen the case of Bancks versus Association newspaper, which is a popular case in the 1952. All my references are included in the written assessment. Firstly, we can say that about discharge of contract, there are three ways parties can be discharged from a contract. Firstly is through performance. That is, when they perform their legal obligations, they are discharged from the contract. That is simple. The second is agreement. If both parties of the contract still have obligations to do, but they come into an agreement that the other party does not have to fulfill their obligation, then they can be discharged from the contract. And finally is through frustration. But frustration is not a simple way. There are many specific conditions that has to be met, like there has to be an event that occurs that was not contemplated by the parties, and the contract is fundamentally different from the original. Then in such cases the contract can be discharged. Discharge of a contract and breach of a contract is very different. Breaching a contract can have legal remedies for the innocent party. Remedies that include damages that are mainly in the form of monetary compensation, or it could be in the form of injunctions, etc. Let's take a simple example. Suppose we order a pizza from Pizza Hut and we order a cheese lover. We ask them to bring the pizza within 15 minutes. They say they will do it, and we wait for around 15 minutes, and when they bring the pizza is very cold, or it's another type of pizza. So that is a breach of conditions, which is an important essential element. Conditions are more important than warranties. But let's take the same example and say that suppose Pizza Hut brought the same pizza that we ordered, but 5 minutes late. Then we can say that they have just breached the warranties of the contract, not the conditions, because conditions are the main part and warranties are the subsidiary of the main purpose. Okay, coming into the main case, talking about Association newspaper versus Bancks. The case took place on 1952 and it was a high court case which involved 5 judges. There was a contract between the newspaper agency and the cartoon artist of the popular Gringer Megs. In the contract, the newspaper agreed to publish the cartoonist's cartoon in the front page of the section for a period of 10 years. During 1951, however, in February, there was a shortage of news ink to be printed, and the comic was printed in the third page instead of the front page. Bancks asserted Association newspaper had breached the conditions of their contract and wanted to terminate the contract. Here, the Association newspaper filed a suit as the plaintiff and sought injunctions against the Bancks as the defendant to restrain his threatened breach of contract. Following the IRAC method, we will now take a closer look at the contract. The issue of the contract is that whether the printing of the comic in the front page of the section is a condition or simply just a warranty of the contract. The relevant law says that if the condition is breached, the innocent party can file for both damages and can terminate the contract. But if the warranty was breached, then the innocent party can only file for damages. Now coming to the relevant law, application of law, while going through the contract, it was found that there are 3 main obligations that Association newspaper had to accomplish. That was, firstly, to print the comics in full page drawings. The second was to print the comic weekly, and finally was to print the comic in the front page of the section. It was of prime importance for the Bancks to receive the prominent public relations. Bancks used the case of White versus Ons Theatre to back up his case. Coming to the conclusion, the judges decided coming to the conclusion from the judges, Bancks won the case and was entitled to sue for damages and can terminate the contract if he wishes. And the appeal for injunction by the plaintiff was denied. Thank you.